listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande. Thanks so much for joining us for this episode of Let's Get Surety. I have with me today co-host Mark McCallum, CEO at NASBP. Hey Mark, thanks for being on.
Hi Kat, it's a pleasure to be here.
It's always good to have you on with me, and especially on a topic like this. We're talking about the importance of standardized construction contracts. It's a pretty good topic.
I happen to love standardized forms, so I'm pretty darn excited about this.
I figured you would be. So to discuss this topic with us today, we have Mike Bomba, Managing Director and Counsel at AIA Contract Documents. Thanks for being on with us, Mike.
Thanks for having me.
So before we dive into this topic, Mike, can you just tell us a little bit about yourself and your background and a little bit about AIA Contract Documents?
Sure. I'm a construction attorney. I've been working with the AIA Contract Documents team for a pretty long time now. I joined the team in 2006, in the summer 2006. So just over 16 years now, and have been enjoying it all along. Still here. Before I was with the AIA, I was in private practice in the DC area. I worked for a DC firm that represented design professionals primarily in construction claims, but also in their contract negotiations and things like that.
So it's great to have you on with us, Mike. And I think a good place to kick us off would be to talk about the value of a standardized contract versus a manuscript.
Sure. I mean, I think one of the most obvious advantages is they're more cost effective. Basically, you're not starting from square one. You're not starting from scratch. There's a low fee of entry compared to what it would cost if you had to retain an attorney to prepare a contract for you from the ground up.
Those build hours can add up.
Yeah, you're looking at a fair number of hours. And a lot of times I feel like they probably end up starting with some of our words anyway. So you may as well go to the source. But I think that another value with standard contracts is, especially with ours, they're so ubiquitous in the industry that everyone sort of is familiar with the vocabulary and the terms. And so everyone's talking the same language. Our documents have been around in some form or fashion since the late 1800s. So a lot of the language is well vetted, which means most importantly that it's well understood by those in the industry. So from the beginning point, you're starting from a perspective of both talking the same language, both have an understanding of what's in the basic document. And so you're really working around the edges about the changes you want to make rather than having to understand the whole document from the beginning as if you were looking at something new for the first time.
And Mike, I imagine whether when you were practicing or, in your capacity with AIA, you probably saw that not all attorneys are even familiar with construction and construction practices. And so if there's a manuscripted agreement, it could vary very widely from accepted practices. Is that true in your experience?
Absolutely. We've run into, we've had people, come up and ask us a question about, as an example, the question, it was very clear that they had no idea how a professional liability insurance policy worked. Their question was clear that they had no idea that there was eroding policy limits in a design professionals agreement. And actually of a similar vein, they asked why the owner could not be added as an additional insured to the PLI policy. So, you get, and this was, not a new attorney to the industry or to the profession. They were new to the industry. They hadn't done any construction law before. And so, I think that even an attorney who has been practicing and has a client come in and say, I've got this construction project. I need some contracts. And in many ways, they're better off starting with what we have as well, because instead of having to, crack open Bruner and O'Connor and read it cover to cover to understand the construction law industry, they can start with our documents, which are, with being around as long as they have and doing what they've been doing, have really provided the framework for the legal world for construction. And so you can start there, have a safe understanding that everything in there, has been vetted, well understood in the industry, and is a good starting point for any project that you need to put together.
Well, and I think that's a wonderful point about the longevity and all the precedent that surrounds the language. And, everybody is trying to get that project finished, their facility built. And having that predictability and consistency has got to be very important to that. Maybe talk a little bit about the fact that AIA has been around and that there's a great deal of case law that has been built up. So exactly perhaps how courts might rule if they're construing that language. Is that true, number one? And number two, is that case law easily, assessed by their attorneys, for example, the client's attorneys?
Yeah, I liked your word predictability, and I think that one of the key factors around our documents is that there is predictability over how the language would be interpreted in court. So there is actually a legal citator. I believe LexisNexis has published it. That tracks, court cases throughout the country, throughout, decades and decades of cases. And it essentially cites which section of our agreement was referenced and, provides a link to it. And so you can trace back how certain provisions have been interpreted by courts throughout time. And that's part of our drafting process too, is we evaluate how courts are interpreting our language to determine if a tweak is necessary. And I think what's interesting in our forms is some of the provisions you can trace back to the late 1800s, early 1900s. In the very first general conditions document, you can see some similar language. It's still there. And so it's kind of stood the test of time. And I think users of our documents can take comfort in that. And then if they find themselves in a dispute, because unfortunately construction, projects, that's like the last phase of the construction project is the claims portion. If you find yourself in a dispute, you want to have clear predictability on how the language of the contract would be interpreted, so that you can apply it to whatever circumstances you have on your case. But absolutely, I think predictability is key, and I think that the history and the consistency of interpretation provides that to users in our documents.
That's great. So tell us a little bit more about starting from the standpoint of an industry developed and promulgated form. What I mean by that is, there are probably a team of folks who are doing that. They're looking at interests, they're looking at best practices, and then coming up with language. Is that a fair assessment of how it's done?
Yeah, that's how I think our documents have been developed for, as long as they've been around. There's always been a committee of industry professionals that comes together to, dissect these things in excruciating detail, compare them to what's going on in the industry and what probably would be best practices. I think that when these things started in the late 1800s, they began the process of defining how the construction industry operated and should operate. They continued to do so to define the standard process for contracting for 140 plus years, and the standard operating procedures and legal interpretations have formed around those standard terms. And I think anybody operating in this industry, what I like to say that known terms equals less risk, unknown terms equals more risk, and not only on a project by project basis, like for each contract, but if you can adapt your internal processes and procedures to a standard operating procedure, you can hopefully almost perfect those risk management processes and procedures that you've built within your firm. And if you have a predictability in how a project is going to be delivered, which the contract can provide that framework, that predictability, then you can really hone your experience and your mechanisms to protect yourself. There's always risk in every project, but it can be managed. And if it's predictable from one project to the next, you can really hone those skills and really avoid and manage most risk. It's when you throw in a variable that you've never dealt with before, or a process that you're not familiar with, or you try something for the first time, that's where you can't predict the outcome as well. I mean, you can never predict the outcome, but I think you understand what I'm getting at. The more you've done something and the more comfortable you are with it, the more comfortable you are with the outcome. First time you're trying something, you don't necessarily know how it's going to go, and that's where you get increased risk. And again, so if you're working from a standard form, and especially one that's helped to define the standard operating procedures in the industry for so long, I think you're better off. I think it's a good way to develop your firm as risk management process around that standard operating procedure.
Yeah, absolutely. I mean, consistency and predictability are certainly key words of comfort to surety underwriters.
Yes.
Obviously, and knowing, how things might evolve, and knowing that a party has a system in place and is utilizing that system, very important. Now, given that long history and consistency, that is not to say that they don't evolve over time, right?
That's true.
And so, language changes. And I know that the AIA forms have evolved over time because they're also looking at best practices, right? But when you know what has changed, also know how it might be interpreted, right?
Yeah. Yep.
So maybe talk a little bit about that.
A lot of our changes are initiated from, if there is a finding in a court case that didn't quite go the way we would have expected, we might tweak language to respond to that. I know there was some language added in this 2017 round to clarify that the indemnity provision in the owner-architect agreements did not include the duty to defend, and that was in response to some court cases that had read into a duty to defend into an indemnity. So, we looked at the court language, or the court opinion. They essentially said what was missing wasn't an interpretation of our documents. It was just a general case. But we looked at the court's opinion, and they essentially said what was missing to allow for it to be read the way we would want it to be read if they were looking at one of our provisions, and we changed it to accommodate it. And it didn't impact all the other states where this would not have been an issue. It was one particular state. I won't call out that particular state, but to allow us to continue for consistent interpretation and do so with a lot of clarity. And we reach out to the industry. Mark, you've been involved in helping to, in your current life, you've been involved in writing these. In a past life, you are even more involved in working with us on these. But we reach out to experts in the industry, depending on which set of documents we're writing, to get their feedback about how things are going in the industry. We experienced a bit of a surprise interpretation on some of the surety language. We adapted and worked together and worked quickly to get something out that was consistent with the way the industry operated. We just had to tweak some language and make sure we didn't have a runaway train going a direction we didn't want it to go.
Well, and I think that's another important point about not only monitoring case law, case precedent, but the fact that your program is responsive to industry feedback and weighing that feedback and coming up with what they think is a fair solution. And I know AIA Documents Program does a lot of outreach to various stakeholders, including NASBP on the bond forms.
Yeah, absolutely. We try to get all the major players involved for each of the agreements with a long drafting process of sharing drafts, individual meetings if appropriate, to really try to come up with language that is. I mean, our goal is to have what we call fair and balanced language. It is not intended to tilt one way or the other, and that is our goal. Now, that doesn't mean everyone's happy with what we write. I feel like we do a good job because every constituency that we work with is never happy with the exact language we come up with. So we got to be hitting it pretty right if that's the case.
Right, because if you only favor
please one of them,
can't be equitable, can it? Right? Yeah. So let me pose maybe a theoretical, mostly theoretical question to you. So, it doesn't seem like construction is very uniform. And what would happen if there wasn't an AIA contract documents program out there? It seems like it serves a very valuable function. I mean, are we, a largely regulated industry in terms of construction, or is that something that it goes in a lot of different directions and you need kind of a unifying voice out there?
Yeah, I mean, if there were no AIA contract documents, I can only imagine it would be some sort of post-apocalyptic type of movie scenario.
Little Mad Max.
Yeah, I think so. Yes, I think so.
Fight of the fittest.
Yeah.
Kind of thing.
It get ugly. It's not construction is not a. I mean, we have building codes, we have things like that, but in terms of the contracting world for construction, there is not a ton of regulations that apply in the construction industry. Think of like tax law, right? I mean, there's a gigantic tax code, so that really defines the landscape in which the tax world operates. Now there's loopholes, there's blurry areas, there's court cases that interpret language and things like that. It's not clear. It's not, as clear cut as one might think, but we don't have that right level of regulation in the construction industry. And
right. It's not as prescriptive. I mean, there are regulations. Certainly contractors go, hey, I feel
regulated.
But it's not like the tax code, where it's very prescriptive as to what you're supposed to do. And there's obviously a lot of complexity.
And so it's largely a common law based body of law, and common law has developed over time, but there's not really, there's not a clear source to go to and say, well, this is what the common law says how a construction project should and would operate. There's you can't just go to a particular source. And I jokingly referenced Bruner and O'Connor, the construction law treatise. I have a copy. It's not in here, but it's 9-10 volumes long. You're not going to just breeze through that and be all, in a couple days and bill your client for it. So, what without our documents, I don't know that there would be as much, there would not be as much uniformity and structure within the industry. I think you would be finding each project would be, you'd be starting from the beginning, and you'd have to try to, depending on your negotiating power, you'd be trying to create your ideal situation, and so rather than coming from it from a standpoint of like, well, we've done projects like this before, we know how this is going to operate. I would imagine contingencies would be larger, fees would be larger. Right. The predictability of outcomes would be a lot less. I think it should provide owners comfort that there is a certain level of standardization in the construction industry, not by regulation, but by practice and documenting it through standard forms like we provide.
Right. And industry action, and certainly, again, maybe from a surety perspective or a credit relationship perspective, that consistency, that standardization is vitally important, particularly when you're underwriting individual contracts.
Yeah, I mean,
you can imagine
the insurance world, the surety world. I'm sure a lot of it is based on hoping for predictability and needing some basic understanding of how a project is going to proceed. And so, if you're starting with a standard form, you're just looking at the changes in determining how those changes would impact your risk profile, your whatever valuation you've put on, for the surety, like for their contractor, whatever risk profile they've assigned to them, how the changes in the contract would impact it, and can make decisions based on that. But it's all starting from some common understanding of what it should be. And I think that, luckily for me, our documents have provided that common understanding for the industry, and will continue to do so.
Now, probably one caveat, and I'd be interested in your thoughts, Mike, is although these can be taken off the shelf, I would think consumers need to understand the context in which they're using it for their particular circumstances. Is that correct? And how should they go about that?
Absolutely. There are many types of ways to deliver a construction project. You have different delivery models, right? You've got design build, you've got the traditional design bid build, right? That's sort of the grandfather of them all. But now you've got design build, you've got CM as advisor, CM as constructor, you've got integrated project delivery. So there's all sorts of these, new and different types of delivery models. And so the first step is you've got to figure out what delivery model are you working in, and choose the right, documents. And it's not just one document too. Any owner working on a construction or looking to build a building, they're not just going to hire, it's not just going to be one person, one entity working on it. There's going to be an architect, there's going to be an engineer, there's going to be a contractor, there's going to be subcontractors and tradespeople and suppliers and insurance people and surety people, right? And so all of that needs to be coordinated. So, you've got all these different players. You want to have consistency of terms throughout all of those different contracts. And, where do you start? Right. And that's what, honestly, then that's probably what our contracts, we kind of divide them up and deliver them by, delivery models. We have like a set of design bid build documents, a set of design build documents, but that within those, they are coordinated and consistent with one another. So while the owner doesn't directly contract with every single party that's going to be working on this project, if they're all using our agreements, they can at least trust, unless somebody butchered them, they can at least trust that they're going to be consistent and coordinated throughout. If there's a waiver of subrogation in the owner-contractor agreement, there's going to be a waiver of subrogation in the owner-architect agreement. And you're not going to have a situation where, unless somebody, again, has messed them up and deleted something, you're not going to be exposed because of lack of coordination.
Well, and I would imagine then that also avoids ambiguities and errors and so forth that you might get by, for example, mixing forms. So would it be a red flag if somebody's using a manuscripted document with an AIA document or another standardized form document with an AIA document? Do you see that as a red flag?
I think so. I think you should try to avoid it. I mean, one of our goals is to write, common provisions the same across all of our documents. And because as soon as any court that is going to be looking at contract language is going to assume that two provisions are written differently for a reason. And then they're going to try and come up with a reason why. And you're probably not going to like that reason why. We actually I think there was a Maryland case recently, and we wrote an amicus brief for it. And I think, if I remember correctly, there was a owner-contractor agreement that was an AIA agreement, and it had the standard waiver of subrogation language in it. But then there was the contractor had hired someone else, and I forget exactly the details of it, but they did not use a standard AIA agreement, and the waiver of subrogation in that contract did not play well with the one that was in ours, and it caused, there was a fire at an apartment building, so the damages were huge. It was no one was in it. Luckily, it was during construction. But the damages were huge, and where a waiver of subrogation would have hopefully cut off all the battling, it didn't, unfortunately, because of the two different types of waiver of subrogation provisions, and it made it all the way up to the Maryland Court of Appeals. And I mean, I'm sure the attorneys did well on it, but I don't think anybody else did.
So, Mike, what bit of advice or other advice would you give surety professionals about AIA forms, what they need to know, and what they can educate clients on, particularly bond producers?
Yeah, I think it would be useful. I think having a working knowledge of what's in especially our owner-contractor agreements would be valuable for the surety bond producers, and being able to recognize when there might be deviations from the standard language and how that may impact their the clients. I'm sorry.
Right. Clients' responsibilities.
Understand, how it impacts their clients' responsibilities. And another thing that's important too about our bond forms and our owner-contractor agreements is consistency in the termination process, clarity on the termination process, because if there's not clarity on when the bond is terminated, when the contract is terminated, there's not clarity on when the bond kicks in. And we try to write ours to be consistent and clear on that respect. But that can be a whole mess for the surety if there's not clarity on when termination has actually occurred and when the surety's responsibilities under the bond might be triggered. There's a whole set of things that have to happen, but that's one of them.
Yeah,
that's a great point. In fact, I should put in a plug for your future appearance about a rundown on the AIA bond forms in the future.
That's you're gonna have to help on that
one. No, but that is a really great point. So I have a question about what you had recently just said.
Mm-hmm.
So delineating those deviations. So if they're using a digital AIA form or an electronic form, is there a way that AIA ensures that those deviations are shown?
Yeah, and it's actually, it's something that it's core to our delivery process. Is that, obviously in the old days when you just bought paper, it was pretty obvious when something was changed. And doing it digitally now, for the most part. As part of the process through our software, it will automatically generate a track changes version of every edit. Now, users have an option to create a clean, if you've really edited a lot, it can kind of get ugly with doing inline edits. And so to allow for that or to accommodate for that, users can provide a clean copy. But they have the body of the contract is clean, but at the end it creates an additions and deletions report. So, if you're receiving a finalized AIA contract document, it will either have the inline edits in it, or at the end, it will have an additions and deletions report. And if it does not have one, the additions and deletions report, you need to ask for it because it does exist. You can't finalize an agreement without it. So that does then allow you to hone in on just what's been changed. Presumably you have a working knowledge of what's in the standard agreement. And then if you can look at, you can really focus on, obviously, always read every word of your contract. But if you really want to see what's different and what, how it's going to impact you from what you're used to or what you usually do, that additions and deletions report, those inline edits will really help focus your attention so that you can, again, save time. It's more cost effective if you're really just focusing on those changes if everything else sort of stays the same.
That is a really critical takeaway point.
Yeah.
Particularly not only for the contractor, but for the surety professionals who are underwriting the obligation potentially to know what's being assumed. One last question, and that is, so when I think of AIA forms, I think of them mostly in private context. Are they used in the public context? And if so, could you kind of characterize that a little bit for us?
Sure, they are used. Obviously, the federal government has GSA and all of its forms. There is federal work that it's used on, but it is used in public work. We have, oftentimes what you'll find is some sort of enabling legislation within an agency. I think a lot of departments of education allow for the use of our documents, either at the state level or at more of a local level. Usually, what you'll find is some sort of enabling legislation that says, you can use these. Oftentimes, you'll also find accompanying with that, you can use these, but here are the required changes that need to be made because. We don't write our agreements to comply with any state or local agency's procurement laws. So inevitably there are edits that have to be made that the public entity will require. And they'll usually delineate those in their regs or in a statute. But we actually have worked with a few local jurisdictions to implement their required changes. Like as an example, we worked with the Kentucky Department of Education. They have used our documents and and we said, you require these changes. They're statutory, so they're non-negotiable. We can do a version of our agreements that show them. So users don't have to edit the agreements every time they want to do a KDE project. And we worked with some other jurisdictions in Rhode Island, I think, have implemented ours, I think statewide, just with modifications on. So any owner-architect agreement, any owner-contractor agreement is based on, it's an AIA agreement with their required modifications.
That's great. Yeah. Very helpful information.
Mm-hmm.
Yeah, it's been really interesting listening to the importance of why standardized documents are so important, especially in construction, which is such a complicated industry.
Yeah, there's a lot of players involved. It's it's not like going to buy something off of a shelf, where you've got one manufacturer. Perhaps we've got a lot of hands in the pot to deal with and figure out how everyone's going to work together.
And Mike, if someone wants to get more information on AIA contract documents, where should they look? Is there a website they should go to, or?
AIA contract docs. I'm sorry, AIA contracts. We'll get that, or we'll get you there. So everything we have is on there. You can get free samples of all of our documents. So if you wanted to check anything out before purchasing, feel free to do so. We also have a lot of other information on there too. A lot of FAQs, a lot of help, a lot of articles. We've all been working on different articles, talking people through things that might come up in the industry. And we have another thing we publish a lot of are guides that go along with our documents. So, like we have new billing information modeling documents out right now. We wrote 50-page guide that goes along with it that discusses each section to provide a little better understanding of how it's supposed to work. We even did a bond form guide.
I think you're correct.
Yeah.
So you guys are good there.
Yeah.
Well, we'll make sure we include that link in the description for today's episode. I think Mark's already invited you back to be with us again sometime,
right.
Mike. So we'll definitely see you on another future episode. But it's been great having you on today.
Thank you. Thanks for having me.
You've been listening to Let's Get Surety. Let me hear your bonding talk. Brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.